We've all seen the headlines, multi-million-dollar settlements, dramatic courtroom victories, and maybe you've wondered, if I sue my employer, will I get a big payout too? Let's talk about the illusion of easy money in employment law and why most lawsuits aren't the goldmine people think they are. The reality, lawsuits take time. They're emotionally draining, legal fees, court costs, and lost time from work all add up. And most cases settle for far less than you'd expect, if they settle at all. So before you picture a six-figure check in your mailbox, let's bust some common myths about employment law. Most people think that suing their employer is a fast track to financial justice. But here's the truth. Most employment lawsuits settle quietly, often for a fraction of what you might think. Why? Because these cases can be hard to prove. You need evidence, documentation, and sometimes witnesses who are often too scared to speak up. And employers will fight back. They have lawyers, they have money, and they're betting that you'll give up before you see the inside of a courtroom. If you do win your case, there are limits on how much you can actually recover. That's because federal employment laws have damage caps. That means there's a legal maximum on how much money a jury can award you for things like emotional distress or punitive damages. Depending on the size of your employer, it can be as little as $50,000 to $300,000, no matter how badly you were treated. One thing to consider is that there can be state law or local claims that do not have damages caps. That's why it's always helpful to talk to a lawyer about what the possible end of your employment lawsuit could look like. Do you have damages caps, or do you have claims that you can file in a forum that does not have damages caps? Employment cases don't move fast. From the moment you file a complaint, you're looking at months, sometimes years of waiting. Mediation, discovery, depositions, court hearings, it's a long process and it takes an emotional toll. Here's what people don't talk about enough: the emotional weight of going up against your employer. You're fighting a company that may have harassed you, retaliated against you, discriminated against you, or pushed you out for speaking up. It's personal. It can reopen wounds you've tried to heal. It can affect your next job, your finances, and your mental health. But here's what else is true. Sometimes standing up is the only way to take your power back. Sometimes it's not about the money. It's about being heard, about making sure your harasser doesn't get away with it. It's about accountability, about truth. Now, with all of that said, you might be wondering, so what can I actually win from an employment case? The truth is, money is only part of the equation, and sometimes it's not even the most important part. Yes, if you win or settle, you may receive a financial compensation. That can include back pay, which is the wages or salary you lost because of a wrongful termination, demotion, or retaliation. There's also front pay, compensation for the future income you're expected to lose because of what your employer did. You can also be awarded emotional distress damages. If you've suffered mental or emotional harm, you may be entitled to damages for that pain. Your attorney's fees and costs could be covered. In many cases, if you win, your employer can be required to pay your legal fees. And finally, there are punitive damages. In rare cases, if your employer's conduct was especially outrageous or malicious, you could be awarded punitive damages meant to punish or deter future misconduct. But financial relief isn't the only thing on the table. Depending on the case, you might also be able to negotiate for a neutral positive job reference, which can make a huge difference in your ability to get hired somewhere else. A written letter of recommendation, particularly in negotiated settlements. Expungement or correcting your personnel file, especially if your employer falsely accused you of misconduct. And finally, a non-disparagement clause to prevent your former employer from bad-mouthing you to future employers. In some cases, even a public acknowledgement or internal policy changes that protect others in the workplace. So no, it's not easy, it's not quick, and it's not a guarantee. Every case is different, and so is every client's goal. Some want justice, some want to protect others, some just want to move on in peace. But what you should know, regardless of your goals, is that you do have rights, and you deserve to understand your options. With the right team beside you, you can hold your employer accountable, not just for yourself, but for every employee after you.